Okay, good afternoon. Welcome to the discussion on patents in architecture and design. What the image that you're seeing on your screen is the Apple Store in New York, which holds a patent, and yet there are scores of students and practicing architects who are inspired by this building. Now, would that be plagiarizing? Isn't copying the best form of flattery? Let us explore some of these issues today. And before I begin, I would just like to also note that, we are in the midst of a terrible situation out there. And it seems a bit surreal that we are having this discussion, but this is our attempt to fight back, to make sure that we are able to continue with the whole act of learning and thinking and not let the situation get us down. So the reason we are having this discussion today is it happens to be the World Intellectual Property Day, and we decided to commemorate this by hosting an online discussion just to start a conversation in the field. So what we'll be doing is along the way we will be hearing thoughts from some of our guest speakers, and then we have discussants who will be joining the discussion, and then we will be opening the floor for questions and answers. What we'll be looking at it is primarily in terms of two categories. So a practice, where we will be exploring the relationship between authorship and creativity, its commercial value and forms of ownership. And because we are based in a university, so we'll be looking at academia, and we are looking at knowledge, whether it should be accessible to all and therefore open source. And also we will be looking at traditional knowledge systems and their location in the world of patenting. And we'll be sort of finding out whether that's, so it's not a pro or a con, it's right now we are discussing every aspect of the issue. We are honored to have with us the Vice Chancellor of Sushant University, Dr. D.N.S. Kumar, who is our keynote speaker for today. We now request Dr. Kumar to share his views with us. Sir?
Well, good afternoon to everybody.
Good afternoon.
Hello,
yes,
am I audible?
Yes, of course.
Yes, I can hear you.
Yeah, good afternoon to everybody. Distinguished guest speakers, other panel members, participants, and organizers for this webinar. It's a very interesting topic and quite relevant to the context. When I say relevant to the context may be economy, or the context may be the university itself. When I say university, Sushant University, as all of us and others know, has 8 schools which are applied, and wherein a lot of innovation and creativity keeps on happening every day, be it a school of architecture or planning and development or design or engineering or whatsoever. So in this process, Sushant University has come its own way of creating a new designs by exhibiting the creativity which is there among the students led by highly intellectual faculty members. When it comes to design, now I will not be coming into the technical aspects because I'm a finance guy. So let me talk from the external perspective of design. See, any design that we take for that matter, what matters most to the thinkers of creating a new design is what kind of values it is going to add to the users of the product or the process which we are going to design. If I give an example, way back in 2003 or 4, when I was interacting with one of the industrialists, and he just told me, I'm planning to create a new product, which is a cylinder trolley. And for me, it appealed what he is talking. He's a man, a CMD with 7 companies, and that too in bearing industry, a well-known industry for whom business was not that tough, because as we all know, except animals and human beings, nothing can move on this earth without bearings. And I was wondering why this person is talking about a cylinder trolley. He explained to me what is the price of it and what is the cost of it. He did not say cost of making, the cost which the customers, the non-users incurs without having this trolley. And he showed me how he had designed it. It's a simple plate with 3 wheels to it, wherein comfortably one can keep a cylinder on it and move around the house. Otherwise, what is to happen? We is to roll the cylinder from entrance of the house till the kitchen or the place of the cylinder. And in the process, the tiles and others is to get damaged. Then I asked him, what is the price of it? He said 195 rupees is the price. And if you look into the design of any product, the second aspect which we should keep in mind is longitude of that particular product. How long that product which you are creating with a new design or with your creativity is going to give the service in terms of value to the customers. He said this product can go, if it is handled well, minimum 10 years. And if it is roughly managed, 6 to 8 years should not be the problem. And when you ascertain the cost of that 195 rupees spread over 10 years period, it was coming high, very negligible one. And this is what appeals to the customer to go for such kind of products. Today in the market, very financially prudent customers, customers who are very conscious about the cost also. They not only think about the product, but also the cost of maintaining that particular product. In finance or in costing, we call it as third aspect of pricing of the product. And many a time, that aspect has been not captured in the price of a product. The cost or the price of the product may be less, but maintenance of that product may be pretty high. Such kind of products in the market have failed. So therefore, as a design thinker, as we go to create a new product design, we should be very conscious in terms of a cost involved in maintaining such designs also. The third aspect which I would like to touch upon is investment aspect. Many a time, many organizations have failed in lack of investing the appropriate amount of investment required for designing the new product, process, or service. And as a result of which, at the designing stage itself, the product has failed in the market. If I have to give an example, a better example, no other product could be better than this example, that is pharma industry. In pharma industry, when we put our intellect together, out of 5 products that we plan to bring in the market, intellectually we designing it, at least 4 products fail at the entry level itself. That is because we don't put right intellect in designing the product. We don't bring right infrastructure in designing the products. So therefore, appropriate amount of investment is very much required. There are successful designs also. If I have to give an example, these examples are there in front of each one of our eyes. When we go to the mall, when we go to the shopping complex, we see the board that is buy 2 get 3 free. So what is all about? This is a very good investment which has been made by the designers of the product, and they have also fixed what is the quantum which can go within 1 year or within 2 years. Within 1 year or 2 years of designing and bringing that product in the market, nearly 40 to 50% of the investment related to the price of the product which they have made, they recover within 1 or 2 years itself. And after 2 years, when you look into the price which was there earlier, 40 to 50% of the price of the product, after second year, that investment is not there, or that cost is not there. Therefore, they are able to push buy 1 get 2 or buy 2 get 3 free and all that. So therefore, while designing any product, investment aspect and right kind of intellect to be brought in for investment is very important. Let me come to educational institutions, designing the programs, designing the schools, designing the universities. Many a time we build beautiful, excellent, very highly attractive looking the physical infrastructure, but we don't put so much of effort in getting a right kind of people for the right education which we are thinking of. Therefore, what happens? Where we had planned during the planning phase, maybe 5,000 admission, we get only 1,000 or 1,500. So therefore, that kind of designing is not one-sided, designing is holistic approach which is required. At the same time, the value is not a one-time, this one-time, expectation by the customers. Customers want different values to the product that you have designed. And that designed product or the service or the process, you cannot think of maintaining it as a rigid design over a period of time. Your design should be a flexible design. Now, if I give an example of Maruti 800, if you take 20 years back, Maruti was costing around 1,80,000 rupees. Maruti 800 I am talking, and today it is more than 2,20,000 rupees. The various values which are coming in Maruti 800 are not the same. They have kept on changing. If you look 15 years back, Maruti 800, the back rear wiper was not there, but today they have added. And for that addition to the design, customer is ready to pay the price now. So therefore, design or any design as a product or a process or a service is not a rigid one. It has to be dynamic. And today, the market, the economy has emerged in such a way wherein we have to customize the designs. We can't say, see, in 1995, when I started my PhD on soft drink industry, that time soft drinks we used to have 350 ml bottles only. And when I made a suggestion to Pepsi and Coca-Cola, you have to come with 150 ml also, you have to come with 1.5 liter also. So that is how your product has to be packaged. So that also is very important. So what I mean to say is, it's a dynamic process, and wherein the value proportion works very well as far as designed to go in the market. I'm sure the organizers have given very good thought in having external speakers like Professor Hemant Jha, Professor Matthew and all. And these deliberations are going to go in terms of touching the minds and heart of the young people who are thinking to build. It may be architectural design, or it may be fashion design, or it may be any product or service design. As a non-design person, whatever came to my mind and whatever I have seen with my industry friends, I have added in terms of finance, in terms of value and resource proposition. And it would be my pleasure to listen to all speakers how this design as a process can be strengthened further. I thank everyone for joining this event, and I wish all the best. Thank you so much.
Thank you so much, sir. Thank you very much. I think the most important takeaway for some of us is the whole idea of failure. That you must be accustomed to that, and that should not set you back. And you should just keep going on and on, because when you innovate, it's always you fail, but that's okay. That it's perfectly fine to do that. Thank you so much. Now I'm going to ask our panelist Matthew to join us. Just 1 minute, Matthew. I'm going to share my screen for a second. Matthew is a lawyer. So when we were just thinking about this event, we were hoping to get as many stakeholders as we possibly could on board to look at the problem from every side, because sometimes artists, creators, architects, we tend to be extremely inclusive, and we thought maybe it's a good idea to throw the field a little open. So Matthew is a lawyer who has worked on IPR matters, but he also has an inclination towards theoretical ruminations, which I discovered on a Sunday afternoon, having a conversation with him, and which I thought was really rare for a lawyer, because we have this impression of lawyers as being, extremely technical. So Matthew, please share your journey in the field of IPR and your views on patenting in the creative field with us, please.
Hi, Nina. Thank you for that introduction. I mean, I don't know if I deserved all of that, but I can tell you that I have read my Tolkien far more times than I have read my Constitution. So maybe I'm a strange lawyer in that context. But yes, I have been ever since law school in the 90s, been thinking about intellectual property rights and how the creative industries can use intellectual property rights to kind of monetize their creative skills and the product, but also how intellectual property rights need to balance that with the interest of the commons, of multiple people having the ability to use a lot of things and stand on the shoulders of giants, so to speak, to create new things. So all intellectual property rights to that extent is a balance. It's a grant of a personal monopoly balanced with the requirement of the public that every ideas be free to wear, right? That said, I just want to expand the topic a little bit beyond just patents to all forms of intellectual property, because I think we're primarily probably an audience of architects, and so copyright, trademark and trade dress, maybe industrial design rights are all probably as important as patents are. And if this would help, let me quickly explain what each one of those things mean. I'm guessing that would be of interest. A copyright is the rights that you have over architectural, two-dimensional for sake of simplicity, two-dimensional architectural drawings, right? Nobody can copy your drawings. That's right to stop people from, literally the right to stop people from copying something is called a copyright. The moment you put something down in 2D, you have copyright over that. Now, if you render it in 3D as well, you have copyright over that as well. The good thing about copyright is that you don't need to register it or go get a certificate or talk to a lawyer. The moment you draw it out, you get copyright. And in the architectural industries, in the design industries, not just architectural, copyright is the mainstay of a professional's rights. So if you were to ask a traditional lawyer, how do I protect my drawings? He would say the law of copyright, right? Everything else is an add-on and solves for like 10% of the problems thereafter, right? The second thing that would apply, the second kind of intellectual property that would apply is what's called trademark. Now, don't think of trademark as Colgate and Gillette and all of those things. Think of trademark as anything that you look at and say, oh, this is created by someone else, right? So, for example, if you look at an architect's results, product, building, and you say, oh, this building must be built by someone else, then that means that the building itself serves as an indication of origin, is a brand by itself, and therefore is amenable to protection as a trademark. Now you might say, hey, that's just nonsense because most buildings look similar from the outside, yada yada, all of that. So I've been living in Bangalore for now 5 years, ever since I came back from my travels, and I, for the last 5 years, lived in houses designed by Shahrukh Mistry. Now, I don't know if all of you know the architect Shahrukh Mistry, but in Bangalore, he's a celebrity. He builds houses with lots of lights. Sorry, Nina, do you know Shahrukh Mistry?
No, I don't actually. I'm sorry.
Okay, so he builds houses with a lot of lights, with a lot of wood, and very rooted to the earth. So lots of red brick, no painting on top of it. The houses are open. There are structures in the middle of the house. There's space to space where there is no roof, so that there's fresh air that comes in. Very classically Shahrukh Mistry. And the thing is, if you go outside and look at a Shahrukh Mistry house, most Bangaloreans know it's a mystery house, right? And if that is the case, that's a trademark. There's another popular builder in Bangalore, led by an architectural husband and wife, called Total Environment.
Yes.
Again,
Total Environment.
very green. Correct. So all of those have become brands. So if you're an architect thinking of how do I protect my drawings, you have two ways to protect it now. One is the artistic side of it, which is the law of copyright, and two is the appearance of it, which is by the law of trademark. And the third, which at least in India is very new, I don't think it's really well explored, but in the US it's very well explored, is the law of industrial designs. If you are trying to protect the non-aesthetic invention that an architect comes up with, then that's by the law of industrial design. And if there is any invention, so to speak, and I would imagine that 99.99% of architectural innovations would not satisfy the test of inventiveness under patent law. But if it does, then theoretically, you could be entitled to a patent for designs as well. So that's the spectrum. And those four things are things you need to think about when thinking about, from a practical perspective, how do I protect my architectural design, right? Even when you think about how do I protect my interior design, right? Those are things you should be thinking about. But tied into this is also a counterculture movement which says everything that I create as an architect is borrowed from the creative works of thousands of architects before me and theory, and therefore that should be free to use, open for everyone to use, and all of that. Now, that's something which is worth thinking about, especially if you're students, academics, etc. Because the other question that you need to ask is, what are we really gaining by getting all these kinds of intellectual property rights? Would we rather just spread the joy that that architectural drawing, painting, innovation brings by letting as many people use it as possible? And is that a better model for me? And I studied in a school designed by a very famous architect called Laurie Baker.
Oh, yes.
And I remember that the Baker method was not patented. The Baker method was not copyrighted. And I spent part of my life in a city by the sea on the Mediterranean coast called Barcelona. And just imagine if Gaudi had tried to patent what he did with light over Casa Baggio. I think the world would be less useful and less interesting. So on that note, I'll stop, Nina, if you have other questions to ask. But like Nina said, I like to ramble. So if you let me speak, I'll speak for hours.
No. That's awesome. That's a great kind of base that you set up. Because we are trying to remain very accessible, but at the same time root ourselves in some very, very core concerns. And you've touched upon all of them very, very successfully. Thank you so much, Matthew. Now we are going to ask Hemant to join in, and Hemant is an architect. He was at the School of Planning and Architecture. He was my junior there, and since then he's been doing a lot of stuff. I'm going to just share my screen to. So that's Hemant for us. He has a master's degree from Yale, and he's been dabbling in the field of architecture and design all over the world. He's been based in the States for some time, but now he's back home and he is in Goa. Lucky him. And he's running a company there, and we'll just hear from him about his journey. Hemant, you want me to share the screen, right?
Yeah, thank you for having me here. Nina, Dr. Kumar, the entire Sushant team. Pleasure to be here. So my name is Hemant, as we've established by now, and I thought I would share with you some experiences from my journey through architecture, product design, and intellectual property. So moving forward, I put this down here. I went to the School of Planning and Architecture. I got my bachelor's degree in architecture there, and I was thinking about what I would say about intellectual property, or what I even know about intellectual property kind of at that time. And it really wasn't very much, but I realized that it was actually these four people who encouraged me to think differently and to think clearly, and often just to think. And I think that was kind of the cornerstone of everything that I've done since then. And when we think about intellectual property and new ideas and sort of new ways of doing things, I think clarity of thought is something that comes to mind as being maybe the single most important thing. And so I just wanted to call them out here. Moving on, after SPA, my first sort of position as an architect was with Joseph Allen Stein in Delhi. And the project that I did with him was not one of his buildings. So here's the India International Center, obviously, fabulous work of architecture. But the project I worked with him on was something that he had wanted to do many years before, but never got around to it, and was the research, design, and development of a set of building blocks, very Lego-like, for constructing just very cool and reasonably priced homes, and airy and green, just like his work really is. So if you look at the next image here, it's I mean, he's done very similar work across different scales, and that's the same way that we were thinking of the house or these building elements as well. So modestly sized in different configurations depending on what people needed. And if you go to the next one, you basically see, what his spaces actually felt like. And they're open, right? They're breathable. There's a good use of local materials and man-made materials. Things are always thought through and they're not prescriptive. And we thought it'd be lovely to actually do something like that with these homes as well. And if you look at the next image there, which is kind of representative of what we were looking to do. Now, the idea here was that these elements that we designed would be freely licensed for manufacture and use, right? So there are plenty of manufacturers in the country who can make products out of concrete or clay. We would design the elements, we would design the configurations into which these elements could go, and then you let people make them and use them as they will, right? So that was my first introduction to the idea of intellectual property and what it meant to kind of create something and then give people the ability to use what you create. So moving on, in '96, I left for Yale. I got a master's degree in architecture there, and I actually spent a lot of my time outside the architecture school because I found that to be a lot more interesting. I studied something called mechanical instrumentation, which was taught at the Graduate School of Chemistry. They would teach you how to make things and make things very precisely and in a very particular way with materials that architects typically don't use. And so I worked on several independent projects that had these unique technical elements, right? And often with the goal of uncovering sort of better functionality. And this is one of them. It's a fountain pen. It's designed for artists. And it's designed to work as easily and simply as a pencil. So when you draw with a pencil, you can basically go left or right, or you go up or down. You can basically use it whichever way you want. But if you try using a fountain pen, you typically have to guide your line work in the way that the fountain pen dictates. And I thought it'd be nice if you could actually make a fountain pen work like a pencil. And so I designed it, I made this, and then I got a call a few days later from the Yale Office of Cooperative Research. It's a really lovely and sort of grand sounding name. But essentially, it's part of the legal team, and they have a very large legal team, as I found out, and they kept tabs on developments that were happening across the university. And anytime there was something that they felt could be patented or would provide some kind of financial benefit to the school, they would kind of reach out, and that was, I guess, part of my contract for being there. So I had many conversations with the Yale Office of Cooperative Research, including the next slide and the ones after that. Every semester I did one project that was, again, independent study. So moved on to designing a turntable. I really liked analog, and so this was the first turntable that I made. Very high precision machines, sort of metals, sapphire bearings, and then if you could just kind of scroll through the next 3 or 4 images, they're all essentially of projects that were done there, and each one received at least some kind of attention.
So it's the same turntable, they're different images of the same thing?
There are 2 images of each turntable. So this is now turntable number 2, which is kind of a different idea, and I wanted to put them all in here because each one of these got the kind of the love and attention of the Office of Cooperative Research, and I still can't get over the name. But I think it was kind of a really good introduction to things and the kinds of things that we normally learn in architecture and design school. So really good first exposure. So I finished my program at Yale, and after school was with Richard Meyer and Partners in New York City, and I was his sole designer, and I designed clocks and watches and light fixtures and furniture for him, and these were sold at museum stores across the world. And as I was putting this together, I thought it was interesting that Richard's name appears very prominently on the dial. And And obviously, as it should. I mean, it was his company, and I simply worked for him, but it was kind of his way of leaving a mark, which was. Um, so after about a year and a half of that, I worked with the Saarinen Design Office. At that point, it was called KRJDA, which was Kevin Roach, John Dinklew and Associates in Connecticut, and I worked on the Museum of Jewish Heritage in New York City. From start to finish. So I saw the entire project through, right from the earliest concept sketches to the time it was built, and at that point I decided that I would prefer to apply my design skills more to products than to architecture. And there was no IP work. There was really nothing that kind of happened there. But then I jumped into working with Sony Electronics, which was a whole different world. I worked with them in Los Angeles and in Japan. My focus was on products for the future. So they were driven by research, like technical research, ethnographic research, predicted sort of future needs in living and working, and developed a series of new products with them and services and experiences. And the goal of this was to sort of inform the technical development that would happen within the company and also to generate patents that they could not only use in their products, but would also sort of disallow other people from doing. And they had a very large sort of internal group that managed all of this. And I got to see that in action. I thought I'd share a couple of images with you. Mechatronic Devices for creating personalized experiences with light and sound. Basically, robotics integrated with consumer electronics. And even today, I think I'm bound by a contract that doesn't really allow me to say very much about them. Otherwise, I would have loved to.
Okay.
Shortly after Sony, I had my first startup, and I think it was actually having learned a lot from the past few years that this was the business model that we had. So ours was a startup focused on the development and licensing of core technologies. So we would create them in-house. We would figure out what the applications might be, and we would create consumer products which would derive from these technologies and put them to use, right? But we wouldn't manufacture them. We would license them to other manufacturers who were already in the business of making and selling similar products. And so the images that you see here, my daughter was about a year and a half old at this time, so we designed a car safety seat for infants, and we designed it to sort of work better, and it had certain mechanisms that were sort of proprietary to us, and this is the way that it looked at the time. And this is the first product that we'd made that we actually licensed to somebody else. I had multiple teams working at the startup at that time. So another thing we were working on in parallel was this, and it was an interactive, sort of intuitive physical interface. And the first application for this was, what you see here on screen and the next screen as well. It was a sort of electronic toy for kids, and the year was 2007. And while we were working on this and we had our prototypes ready and we'd be refining them and playing with them, Steve Jobs announced the first iPhone that same year. And we took one look at the iPhone and we kind of wrapped up this project because you could almost see what was going to come next, right? And so sort of how powerful that device and that technology and that approach was. And so that was kind of a little bit of a landmark moment for us. We did a lot of patent work during this time. Then from 2009 to 14, I did a few things. I started a nonprofit called Wheelwell, and I also started teaching at both the Institute of Design at IIT and the Kellogg School of Management at Northwestern University. And this was the program that I created and I taught, and it was about design and social entrepreneurship. Right, it was a master's level program and was focused on bringing good ideas to life. Now, all of us, who go to design school think we should do something good for society, we should do something good for people, and we try to, but very often there isn't a structured approach that allows us to do this effectively. And so a lot of these things that we think of basically remain on paper, right? So what I was teaching was, how do you do good for the world in a way that allows you to pay yourself and your team a reasonable salary? and also provides you with the funding to further your research and development, right, to take your ideas forward. So again, we would license the IP and expand the reach of the idea. What you see here are early prototypes of a wheelchair for people with spinal cord injury, and people who have serious spinal cord injury basically live and work in a wheelchair sort of 24/7. And this was a student project, and when we would do the midterm review or the end of year review, as critics, I would invite stakeholders who would ultimately be involved in the process, right? So we had people in wheelchairs who were the critics for design. So there were no designers, there were no architects that we called in, but we actually called in real wheelchair users. We called in doctors and nurses and nursing assistants, and I always called in a patent attorney. Again, with a view that I think it's very important for students and working professionals to kind of realize the role that all of these people play in the ecosystem of bringing an idea to life. Moving on from there, I was asked by the Goldswitch family to come and establish the Goldswitch Design Center, and so I was there from 2014 to 18. Goldswitch, as you know, as a company, you know, everybody uses Goldswitch products. I mean, everybody has something or the other, right? But what was very interesting, actually, in the previous slide, was the padlock. And that padlock is at least 50 years old, and you can see engraved on the padlock is a patent number, and that's from 1951. And I thought it was actually super interesting that the company has been sort of patenting their ideas for a long time. Obviously for things like padlocks. And what we did was actually take this idea even further. So the kinds of projects that we worked on were quite a bit different. So they were always very sort of forward or future looking. So there were, the application of robotics in complex manufacturing. Next, we looked at things like composting for urban and semi-urban areas, sort of developing both devices, but also the methodology, right? So the temperature control, the humidity control, the kinds of microorganisms that are required for composting, and how do they all work together? High density clean battery technology. So again, things that are very new and sort of very, very much sort of top of mind for us. And next, we also worked with artisans and industry together for a wide range of home goods. We launched a consumer brand called Script, which does a lot of furniture and home goods. And we also started this program called Goldswitch Design Lab. Now, what was interesting about my experience at Goldswitch was that while they do have a history of making products that go back more than 100 years, there wasn't really, when we set up the Innovation Center, there wasn't really a mechanism in place to accept all the new ideas that were coming through from the center sort of very, very quickly. And I remember speaking to the attorneys who were in-house, and they were not IP people. And so they introduced me to other companies, and we actually went and spoke to them. And very often I would find that they weren't really specialists in IP. And because I'd done a bunch of work in the US, I could sort of tell, until we finally found this company in Delhi. And Matthew, maybe we should have found you, but we didn't. So that's kind of that's our bad. But we found this company in Delhi that really seemed to know their stuff. And I said, how is it that you guys are like totally on top of things? And we've not been able to find anybody else so far. And they said that's primarily because 90% of their work actually was outsourced from the US. And in their mind, there were not a lot of Indian companies or a lot of Indian educational institutions that were actively protecting their IP. And as a result, there really weren't too many companies or IP firms in India at that time. So moving on, a few years later, this is the company that I set up next. And it's also a startup. It's called Honest Structures. We design and make what we believe is the cleanest line of furniture and organization systems in the world. And it is a very sort of systems-based approach. So as you scroll through the next 4 or 5 slides, you can actually see the different types of configurations that we can make with our products. So again, very much designed like you would a Lego. So things come together very quickly and very easily. They also come apart quite easily should they need to be recycled or refinished at any time. And I won't take up a whole lot of your time kind of talking about our work here. But this is really kind of what we're all about, right? And we've spent the last 2 years actually developing lots of methods for our products to go together. And we're in the process of actually filing a few patents to do this. Products have been used at a few places, not at Sushant, unfortunately, but we do have products at the CEP library in Ahmedabad. Going forward, we've got products used by Gensler Architects in Bangalore, by Cora Jeans. To keep going, we've done projects at schools. So you see our sort of modular systems at work here. So lots and lots of different applications for what we do. And there are very few components that basically come together in all these different ways. And that was the goal, which we're still working towards. I've sent along a couple of links. If anybody's interested, please visit honeststructures.com. Obviously, I can talk offline if you'd like. And my last slide is, I think that's pretty much it.
Thank you.
So that's been our journey through this world.
Okay, so thank you so much. That was amazing. Yeah, and so now we're going to just throw the entire discussion open. And I have a few questions which I'm going to sort of ask. So I'm going to introduce our three discussants who are here with us. There is Sasi. Hemant knows him because I think they were in the same batch at NIT, and then they parted ways. So he had School of Design here. And then we have Dr. Latika Singh, and we have Dr. Kanupriya. So Dr. Singh is from the School of Engineering, and she's going to just shed a little bit of light on the technology part of it. And then we have Dr. Kanupriya, who will sort of just talk a little more about what Matthew has, or a little more details, so that we can have kind of a discussion holistic. So just 1 minute. Okay, so the first question that I'm going to ask about is this new thing called the NFT, which is called a non-fungible technology, and I think I need to shed some light on that.
Thank you, Nina. It's a very good discussion. I'm learning so many new things from here because I come from a different background. But if you honestly ask me what NFT is, it stands for non-fungible token, like you said. And you can think of them as digital tokens that are tied to assets. So it can be bought, it can be sold, and these can be traded as well. These can be for anything which you can talk about, which is there in the digital space rather than the physical space. So I can say this is a very disruptive technology which has given a framework for selling the digital art, which so far we have been seeing just, taken for granted that it's been just free over the internet or something. Technology wise, if you want to understand, it's like a computer file which has a digital proof of ownership and authenticity, or you can say it has a digital signature. You can also understand it as a Bitcoin. However, because the underlying technology of blockchain is same, the only difference is that it is non-fungible, whereas the Bitcoin is always transferred between people. So artists who want to sell their framework, they have to actually go to a marketplace. They have to sort of mint digital tokens, upload and validate their information that this is something which is new. They can then, list their prices for the auction. So I can say it has given a very, very good space opportunity to the artists who are in the digital world. And business-wise, if you ask me, I can tell you one such gateway for selling the art or buying the art or doing the trading is Nifty Gateway, which was incepted last year only, and it has been doing the transaction of more than $100 million during last year itself, which is the first year of inception. If the audience wants to have a feel of what this is like, you can go to a site which is called CryptoKitties. It's a site called cryptokitties.com, and over last 1 year only, the fans have spent more than 32 billion collecting and trading the kitties. So there, what you can do in this site is you can actually buy a kitty, and not only buy, you can do breeding as well. You can create new kind of kitties, and you can trade your kitties as well. So I hope this was clear to people.
Oh God, that was so interesting. Oh, that was amazing. So yeah, when we heard about NFTs and of course, we were looking into the world about, we were going to ask Sushant to share with us a little more about instrumentation, and then let's give us a short update on what is the legal status of NFTs.
I'm sorry, Nina, you're not audible.
I'm not?
Hello?
Okay.
Can you repeat your question, please?
1 second. I'm going to just try and go into my... One. Am I audible now?
Yes.
Excellent. No, I said I was just thanking you so much,
Okay,
Latika,
all right.
for giving us update on that, and so we were just we just knew what NFTs are completely as a very general idea, and you've been able to sort of clarify that for us. And I'm going to just ask Sasi to come in for a bit here and tell us a little about digital art and what is the status of ownership of digital art. How do you do that? And is there stuff like that happening in India today? Sasi, I can't hear you. Can everyone else hear Sasi?
No, Sasi, we can't hear you.
Sasi, not audible? Okay, while Sasi works out his technology, I'm going to ask Matthew to come in for a bit and help us with what's happening in the world of NFTs in India today in terms of their legality.
Hi, Nina. Yes, sure. So I remember having this conversation with you a couple of weeks back, I think. Short answer, NFTs are non-fungible, which means they are unique. And therefore, the moment they're unique, they're a little different from Bitcoin because all of those coins are fungible, therefore not unique. Therefore, there are no legal problems with the issuance, use, or exchange of NFTs as a way of monetizing, showing proof of title for digital art. And before you turn around to me and say, oh, Matthew, but who's going to pay for digital art? The most expensive one till date has gone for, I think, USD 400,000. Right? So this is not...
it's big money, yes, I know.
Go on, Nina.
Yeah, so in India, this whole, and I know internationally, I've been sort of reading up a little on the trends. So in India, this thing is happening. So digital art is on the stage, so as to speak. It's being created, and there is monetization of it. Is that happening today?
Yeah. So just by way of example, and I can't take names, I just received an email about 7 hours ago from one of the big four saying one of my clients wants to structure a NFT exchange. Can you help? Which is basically a place where you can bid, auction, pay, all of that. So yes, it's happening. It's not happening at the scale that it is in the US. there's lesser money involved,
Obviously.
but it's definitely happening. And I know multiple artists who are thinking of using it to kind of monetize their art. I think Shashi's back though.
Yeah.
Yeah, can you hear me now? Can you hear me now?
Yes. Great.
Yes.
Great.
Okay.
Yeah.
Yeah. I think there's always some problems. Technology is still not up to the mark sometimes. So it's a pleasure to be here, and it's one thing Hemant didn't tell us is that he is a product designer first, and then went on to become an architect later. Anyway, so
Yeah.
and I think that spirit stays in him, that spirit continues. And I think I was an architect first who became a product designer. So it's really the other way around. So, and that's where I think the whole discussion is also because where does one draw the line, which is what is somebody's property or somebody else's property? Where are those overlaps which actually allow one to cross over from one to the other? Where do we cease to become designers and engineers, and where do the engineers cease to become engineers and become designers, or the lawyers? So I think that's really the crux of all this discussion, because when we talk of intellectual property, we talk of patents, it's a lot of different people who are coming together to actually create that. It's not one person. And I think the question that you were talking about, the NFTs in art, I think this has become a need because digital, unlike patents, which are usually given to products which are tangible, which are you can hold in your hand and which you can, see a signature at the back maybe. Even if you look at an artwork or a painting which is signed by someone, that signature of authenticity is there at the back, physically available to you. But in a digital form, how do you do that? You can't do that, right? There are so many tools, so many techniques available where you can change something, you can copy something, all of that. So technology is the only way to actually give that authenticity, because the encryption and the code that goes behind that encryption is something that is very, very difficult to crack. And that is, I think, the crux of having to give this sort of authenticity to digital works. And as we see, as Matthew had also just mentioned, there's a whole lot of authentication of artworks which are happening. I mean, I was reading up some time ago artworks which are being sold in millions, but the authentication comes through the NFT token, right? And the fact that it's literally the other side of the glass. This side of the glass is the physical artwork, which is tangible, movable, and authentic. You can authenticate it on its own. And on the other side of the glass is this whole digital stuff, which requires this sort of technology to give it its authenticity. As we speak in India, I mean, for example, there's a new gallery called terrain.art, which is entirely trying to create its worth through blockchain-based models for digital. Well, the art that they're working with is physical, but eventually that's the way it's going. So it's definitely going to occupy a large part of our ecosystem.
Correct. Great. Thank you so much for updating us on that. So we'll now jump across to the knowledge part of it. And Sasi started off this whole kind of dialogue about, knowledge and creativity. Hemant has talked about it, and Dr. Kumar talked about it at the beginning as a keynote thing that, should knowledge be out there for everyone to take, or should there be ownership? So I'm going to ask Hemant to just come in for a bit, because I'm going to give him the location of the for it that knowledge should be. I'm going to share with us for a minute as to why should knowledge be patented, Hemant.
So I think when an individual or a company tries to do something, right? So if you're an individual architect, you're a product designer, whatever, you actually put a lot of yourself into creating whatever it is that you're working on, right? And that a lot of yourself might be, it might be time, it might be money, it might be your expertise. And then at the end of the day, you want it all to come to life in a way that you feel is maybe the best way possible, right? And this could be obviously the work of a team as well. The issue that I have with, a completely sort of open sharing of information or knowledge is that once it's out of your hands, you don't really know exactly how it's going to be used, right? So my approach usually has been work on it, invest your energies and time and resources into it, do a really, really good job, make sure that you have some kind of protection for it, right? And if you really want it out in the world at no cost to anybody, then license it openly, right? License it for no fee. But what that means is, in the case of the wheelchair, for example, if it's manufactured by 6 different manufacturers across the world, they essentially have to do it in the way that it's been designed, right? They cannot randomly change a spec. They can't make it, not quite as well, for example. So I think it allows one to exercise, and it's kind of a dirty word at this point, but allows one to exercise a bit of control over what ultimately happens to your idea. Right. I'm not a massive, so that's basically sort of my point of view on this.
Okay. That sort of sets up one end of the thing. So you mentioned the GPL, the sort of having a generalized license. I'm going to ask Dr. Kanupriya to come in here and share with us a little bit. Matthew already started off this conversation on the differences between a trademark and a copyright. And then there is something called a utility patent, there's something called a design patent, and then there's a GPL. So if you can, just give us a short kind of a 101 refresher course as non-legal people as to what are the various options that are available to us if we are looking at owning or sort of putting some kind of ownership to knowledge.
Yeah, so welcome everyone. So the thing is, IPR, we call it as knowledge which is very not tangible, something which is intangible. So Matthew has already specified that there are various, options which are available to protect your intangible property. One is copyright, patent, trademark, and then one which he has slightly focused upon is design. Because if we talk about design is specifically when Dr. Sasi said, that I'm a product designer. So I think product design is very much in vogue these days, and designers are not only limited to their creativity on paper, but in products as well nowadays. So in order to ensure the protection of knowledge, which anyone has created through their creativity, through their innovation, is very much essential nowadays. Gone are the days when, everything was available online and you could easily grab it. Now it can easily be sued. But how to prove that, yes, you are the original creator? For that, registration is mandatory. Registration is the sole proof, whether it is a design or a copyright or a patent or a trademark. You need to get it registered. Once you get it registered, then you can claim your ownership on that. This is very much essential. And when we talk about design, Matthew rightly said that it is not widely used in India, but if you go globally, it is much more used than copyright when it comes to design sector. Because design is categorically for design. I would like to highlight a very recent case on this. If all the presenters as well as the attendees have heard about it, Crocs filed a case against the other slipper manufacturers, footwear manufacturers, that they have copied the design of the Crocs clogs, categorically the clogs which were made by Crocs. So they had already registered it under Designs Act, but the court, they gave a different opinion. Why? Because there's a difference between what design and what copyright is. Design to be registered must be unique, must be innovative. It has nothing to do with the function. The claim which was made by Crocs was rejected by the courts, and the other manufacturers were given the freedom to manufacture the same designs because there was no uniqueness, there was no innovative concept in the manufacture of those clogs. So there is a technicality which has to be involved in every domain. So for copyright, it has to be functional. It must be utilized next, but a design is only for the beautifying purpose or only for the purpose of visual portrayal. A very, there's another controversy which is going on relating to if most of us has seen that, Hanuman pictorial behind a kind of a sticker which is pasted on the cars and autos on the rear.
Yeah.
Yes. So there's a talk which is going on that it is also to be registered. So there's one particular person who is actually the creator of that particular design. So since he didn't get it registered, it has been sold without any protection. But that is not easy to create. So designs like this can also be created, can also be protected.
Excellent. Thank you so much, Kanu. That was so kind of, sort of rooted the conversation in India, in our context. And I'm going to ask the final question, which is my favorite, which is about, traditional knowledge systems. And I'm going to ask Matthew to come in here. So traditionally we had knowledge systems which were without authors, they were not owned, it was knowledge which was out there. And along the way, it morphed. And today we are looking at, traditional knowledge system as a field of knowledge. What is the legal status? And we are actually looking at IPRs being filed now for Haldi and for Neem. And so can you just give us a short update on that, Matthew?
Yeah, so sure, that's kind of topical as well. I think there are, let's look at traditional knowledge and say traditional medicine, right? There are secrets in traditional systems of medical knowledge which are useful for modern science. Now, there have been historical attempts to take that away and to protect those in countries which do not know that it pre-exists. Right? For example, the health effects of turmeric, I think somebody in the US tried protecting. Similarly, various other traditional forms of medicine, different companies in the West have tried to protect. I think our interest is primarily in making sure that they're free to air, because you can't try and protect something that thousands of people have used for hundreds of years, right? You can only make sure that nobody else stops us from keeping on using that. So for that, the government has what's called the TKDL, which is the Traditional Knowledge Digital Library. Different government agencies across the world will check to see if different patents have already been registered in the TKDL, and if it is registered, then you can't grant patents on that. So that's one rather important step that the government has taken. The second is, and I think there's a national debate over, okay, no one individual can monopolize traditional knowledge, but is there any reason why which India should benefit from India's traditional knowledge, right? Or should it be free for the whole world to use? The debate going on, it's not yet resolved. I don't think the government has the necessary global political heft to kind of introduce a new system of IP that doesn't exist. But it's a good debate to be engaged in. And the third thing is, of course, if you're talking about names of things, right, that are tied to a particular city, let's say Lucknowi, whatever, or Hyderabadi, whatever. Should we get trademark rights over that? And I think courts as well, like trademark registries have been very proactive in saying, hey, if it's Pochampalli silk, then nobody else can claim unless it's that. Or the French courts have said, if we call it a Bordeaux, it has to be a Bordeaux. We call it Champagne, it has
Okay.
to be from Champagne. All of those have also come up. I wonder if a Lucknowi biryani would be entitled to. I think it should, but that's on the lighter side, yeah. But yeah, that's the state
Yeah.
of traditional knowledge in India.
Great,
Legally.
great. Thank you so much. Thank you very much. So I would have wanted to go on longer, but it's 5:21. We are exactly 20 minutes over time, and that's not very efficient. So I'm going to just thank everyone profusely for doing this, and I'm going to now hand this over to Himanshu. Himanshu, if you can come in.
Thanks, Nina. Before when I say anything, there are two more questions asked by our
Oh.
attendees. One is, yeah. So one is raised by Sachin Dutt. He is a doctor and professor in design school, and he says, and he's asking about and this is open to the panelist. He's asking about the open source revolution that has taken place over so many decades, and people are favoring that. So how is that damaging the knowledge per se, and what are the pros and cons of having it? And I agree in one way or the other with Sachin, because that was my question as well, and I'm a huge fan of open source. When I'll give you an example of the system that I'm using Linux, and I've chucked out Windows for a very long time. So the question is open to all the panelists. If anyone can shed some light on this open source movement that is taking place.
Okay. Anyone wants to volunteer?
Matthew or Hemant,
Yeah.
because.
So I stopped myself because I thought I was talking too much. But anyway, so the open source movement is a movement which says that I will give what I make to the commons, and multiple variations of it, but different people can use it in multiple ways. Some say you can make money off it if you want. Some say you can't make money off it. That's basically the open source movement per se. The open source movement suffers what my professor at Oxford used to call, suffers from what's called the tragedy of the commons, which is basically the idea that, yeah, it's everybody, so I'm not going to take care of it, right? It's what but that the fact that you don't have open source, the opposite of that, is what a professor at Berkeley would say is the tragedy of the anti-commons, which is that you keep it only to yourself and you don't let anybody else profit from it, and then you're not incentivized properly to develop, so the nation or the society does not benefit from it. It's an interesting debate. I think there are good examples of the tragedy of the commons. I think Google Chrome versus Mozilla Firefox is a good example of the tragedy of the commons, I think. 20 years ago, when Netscape Navigator opened everything up, we thought Mozilla would be the next great thing. Microsoft stomped over them until Google Chrome came. So that's a good example of where that went. And the tragedy of the anti-commons is just take a look at COVID vaccines today, right, and see how protected they are and how few supply there is, and that's a good example of the other side. I think we'll have to balance both, and I leave it at that. I have personal views, but then that someone needs to buy me a cup of chai and we can talk about it.
Himanshu, you know
Hemant,
what
would
to
you
do
like?
now, right?
Yeah, I know.
would
Hemant,
actually.
would you like to throw some light on this for a minute?
So I think, personally, I think it's a good idea in principle, and I think it's a lovely thought that there are ideas that have been created by people that are then available for anybody else to use, right? My concern is always about, what people are going to be able to do with those ideas. and that's a slightly sort of kind of slightly off topic. But to your example about Linux. Right, so Linux is technically open source, but there are enough companies that have grown up around the idea of Linux, right? So if you use Red Hat, there's certain advantages that you might get to whatever it is, after sales service or something like that. So I think while open source is a fabulous idea, there's absolutely no reason why one has to kind of either go open source or not. I mean, you can go open source and you can kind of build on top of it, right? So as a starting point, I think for a lot of people, I think that's absolutely wonderful. There's no reason to. I can't think of any downside really.
Because I think in way back in 1999, University of Texas, and there were two more companies, Architectonics and Earthnomond something, I don't remember now. But these two companies plus University of Texas, they joined hands together to develop their own city by engaging the citizens and the residents. So that was the first example where the idea of open source came in. And a decade later, in 2008, in one of the TED Talks, the open source architecture. So so from technology, that concept has moved into design, and so suddenly that concept of open source architecture got a wider audience, where the designs are just uploaded and anybody can download and makeshift those designs for their personal needs. So it's a different. I mean, everybody would take a different take on this and move forward, but when both pros and cons are associated with this idea, and I don't know how longer it can be. It can move on. Moving on to next question, Pratima Kiran Mandali has asked, and it's a two-part question, and I think Kanupriya and Matthew will be able to answer this. When copyright protects building, why do patent them again? And what kind of strategy protection should be there between a patent attorney and an architect when we talk about a project or a product?
Let me take the easier one. Kanu, you want to go first? Sorry.
All right. So there's a difference between copyright and patent, as Matthew had already elaborated. So any design on paper, the two-dimensional design on a paper is to be copyrighted. Whereas patent is either a process or a product which has to be patented. Again, the role played is whether it is innovative or not. Copyright is your own work, you can get it copyright in your name, so that it is not to be copied by somebody else. But when we say patenting, it has to be innovative. It shouldn't have existed earlier. And when we say the buildings per se cannot be patented unless and until there's a special feature which is associated with the building. So if Matthew can elaborate a little more on that.
Right, yeah, so I mean, the easiest way to understand this for non-lawyers is to say that copyright is a right against copy. Right, so basically if I make the same thing without copying, then it's not violation of copyright. So copyright is a very thin protection. Patent is a far stronger protection. It doesn't look into whether you copied it or not. If it's been copied, if it is identical or close to identical, then it is a infringement of patent. So patent is far stronger protection. Again, going back to the idea of question of so the government has classified. Sorry, my dog wants to participate. But the government has classified certain things into copyrightable and certain things into patentable, with the idea that patentable goods should satisfy a much higher threshold because they're getting a much stronger monopoly. That was a tougher question. The easier question was, what should I do with a lawyer? I don't know how you deal with lawyers. Yeah, they're all pain in their own way. But so the law says if you tell me something. Sorry, Nina, go on.
I said we try not to do
No, but the law is very clear. If you tell the lawyer something as a lawyer, the lawyer has to keep it confidential, even if you don't sign a non-disclosure agreement. If you want, you can get them to sign a one-page non-disclosure agreement. Many traditional lawyers will get insulted if you tell them, I want to sign a non-disclosure agreement. To my mind, that's unreasonable. I think if someone wants you to sign that agreement, you should. Because if you go and disclose that to any third person, your lawyer will say, no, sign non-disclosure agreement. Only the lawyer is exempt from that requirement, right? So I think you should sign an NDA. We sign NDAs. Sorry?
To my mind, all the new IPR law firms, they make it mandatory as part of the agreement with the client. So it's a mandatory clause within the agreement.
Yeah, but it's their language as opposed to me going and so what usually happens is before you get into an engagement letter, you tell them what the problem is, they'll give you solutions, then there's a 1 hour conversation, uske baad you get into an engagement letter, right? So the question is, can I go to a lawyer and say, oh, I have something confidential to say, here, please sign my confidentiality agreement. My take is, I don't see a problem with it, but 99% of my peers would object, including the sole IP firms. All of them would object because finally, why should I sign it, right? It's like you're distrusting me from day one. I don't look at it that way. I think many of us don't anymore. But the traditional way would be the lawyer would say, turn around and say, trust me.
Yes, Himanshu.
I think these were the only 2 questions. In case attendees have any more question or anything to say, please do write in the chat box.
And we are going to share everyone's emails, and you can email them, you can email us. We intend for this to be a continuous dialogue. This is not just a one-off thing. We've started a conversation. We intend to follow it up in the near future, sort of go into greater detail, pick up separate aspects, see what it is that interests us and also interests the audience, and continue with the conversation for sure. So now I'm going to just ask Himanshu to, so if Himanshu can do the vote of thanks and we can sort of wind up the proceedings, Himanshu.
It's really my pleasure. I think this conversation was really needed for us designers to very subtly kind of elude the idea of patenting their products and designs. So on behalf of School of Art and Architecture, Sushant University, I would like to thank Dr. D.N.S. Kumar, Vice Chancellor of Sushant University, for those opening remarks of where he mentioned the combination of cost, investment, and intelligence. And I know, sir, that very profoundly you are pushing us professors to seek patents. And I'm very sure that your words, professors in architecture and in design and the attendees will take it up more seriously. I would like to deeply thank our experts, Mr. Hemant and Mr. Matthew, for a wonderful insight through their presentation and the work display. I'm sure this will channelize our students and professors and other professionals who have joined us today and deep dive into the process of patent and strengthen their own skills. I would like to thank Dr. Vibhuti Sachdev, Dean, School of Art and Architecture, and Professor Nina for conceptualizing and developing this webinar so that the young designers can take this journey to find abundant creativity and have a clear distinction between what's authorship and what's open source and further develop their methodologies. I would also like to thank Professor Sasi Menon, Dean School of Design, Dr. Kanupriya, Associate Dean of School of Law, Dr. Latika Singh, Associate Dean of School of Engineering and Technology, for raising interesting discussions and pertinent points for applying the scheme of patenting and superbly blending these 3 fields together. I would also like to thank Assistant Professor Samriti Bhalera for developing the creatives for this particular webinar. And last but not the least, thank you all the attendees and participants who have joined us today and making this event a successful event. And I'm hoping and I'm pretty sure from this discussion you will take the insights further and try to at least patent your projects and work. Thank you so much.
Thank you so much, Himanshu, and thank you so much, Hemant. Always a pleasure. And Matthew, we have to continue this conversation. It's going to happen soon. Thank you so much, Sasi and Kanu and Latika. It was very short notice, I know, but I was telling Vibhuti, I said, you know what, it's that the World Intellectual Property Day, we must do something. And I'm so thankful to all of you within the midst of your very, very busy schedules. You were able to take the time out. And I'm sorry that we got overtime. I'm just hoping that the conversation was interesting enough for us not to get too bored with this. So yeah, thank you so much, and looking forward to continuing this conversation in the future. Thank you so much.
Thank you very much.
Pleasure.
Thank you, everyone.
See you, Hemant.
Thank you. Bye.
Bye.
And any further questions, we'll share it with the panelists to answer.
Yes.
Sounds
Yes.
good.
Okay.
Have a good evening,
Thank
everyone.
you.
Thank you all.
Thank you so much.
Thank you.